Mr. Caterson drove 40 miles with his 14-year-old son Brian and a friend, Mr. Mackey, to the town of Casino, where Mr. Mackey wanted to get on the Sydney to Brisbane Railway. The train arrived and Mr. Caterson went onto the train to help the 67-year-old Mr. Mackey with his bags. Young Brian stayed on the platform. Once the bags were aboard, Mr. Caterson went to leave, but found that the train had already started to move. There had been no warning that the train was about to start moving, and the next station was 80 miles away. If Mr. Caterson was caught on the train, his son might be left alone in a strange town far from home for many hours. The train wasn't going quickly, and Mr. Caterson tried to jump off. He stepped off and steadied himself by grabbing a bar on the train, but the train was accelerating, and he was dragged and fell between the train and the platform. He sued in negligence because he was injured. One response by the other side was that he had conducted contributory negligence by trying to jump off a moving train. The defendants said that this was an inherently risky activity and that he himself had been negligent by accepting that risk. There was a doctrine of law that said that if a person is caught in the agony of the moment and has no time to think when faced with a risk, they can't be guilty of contributory negligence. In this case, though, the only outcome if he had been caught on the train was inconvenience to him and his son. Was this enough? The court said yes. Justice Gibbs said, where a plaintiff has, by reason of the negligence of the defendant, been so placed that he can only escape from inconvenience by taking a risk, the question whether his action in taking the risk is unreasonable is to be answered by weighing the degree of inconvenience to which he will be subjected against the risk that he takes in order to try to escape from it. In this case, Justice Gibbs found that the inconvenience arising from a child being left unattended for many hours in a strange town was sufficient to justify Mr. Caterson's attempt to get off the train. There was no contributory negligence, and Mr. Caterson was entitled to damages.